Partition that's in the contract.
Thank
The rest of it. All the products.
Good morning. Please state your name.
Morning, my name is Jonathan Arguelles.
And Mr. Arguelles, this is the time for your initial appearance. You're here on charges of theft of a firearm, which is a felony offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release. I have reviewed the interim complaint, which describes the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services that lets me know whether you have any prior criminal history. It also lets me know what information you were able to provide regarding your ties to the community and any references, as well as their assessments and recommendations. I have also reviewed the state's recommendation, which is that you be held on a bond of $7,500 and if released to pretrial services. Would the state like to be heard further?
No, Your Honor.
Thank you, and defense.
Yes, Your Honor, I'd ask that you release Mr. Arguelles to pretrial services. This is one count of an F6 offense. He has no felony criminal history. Based on what the state has brought here, which is just one count of theft of a firearm, he would be probation available at trial if this was to go to trial tomorrow. It would be undesignated available. Given the charges here. I understand that there's kind of more to the situation described in the statement of probable cause than what's actually charged here. But what's relevant for the purpose of this count is that this is not charged as a violent offense. It's not charged as a DV offense. It's charged as a single count of theft as an F6. So Mr. Arguelles has, as I said, no felony criminal history. Pretrial services, noted that much, as well as no recent failures to appear in what I can only assume would be misdemeanor level charges, older than 2 years. Additionally, Your Honor, it does appear that Mr. Arguelles has a place to go to. He's got a home. He lives out here in Tucson. He's working. Pretrial services did get in touch with his sister, so he's got an alternate in Peoria, Arizona, in a different county, if the state is concerned or the court is concerned about further contact. I'm sure that could be avoided if he is in Maricopa County and not Pima. And so for these reasons, Your Honor, I think pretrial services is going to be more than sufficient to ensure his participation in his case, protect the victim, protect the community, and ensure that he's not a flight risk. So I'm asking that you release him, or, if in the alternative you're considering a bond, Your Honor, I would ask that you impose a nominal one such that he could post that and secure his release. Thank you.
Thank you. Mr. Arguelles, I am going to order that you are released to pretrial services. No alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons. You must surrender any firearms that are in your possession. Monitoring or treatment is directed by pretrial services. No contact with the alleged victim. Do not return to the incident location. Were you living there?
Yes, I was.
All right, so I will order that you may return once with a police escort to pick up your belongings. You'll take my order to the nearest police station and they'll escort you there to pick up your belongings. Your next court date will be on October 27th at 1:30 for a preliminary hearing. If you fail to appear, a warrant can issue for your arrest. Do you understand, sir?
Yes.
Thanks, that's all for today.
Mr. Cruz.
Did I not put in the right one? I could have sworn I changed it. Oh no, he's released. Okay. Yeah. All right. Please state your name.
Jason Roman Cruz.
Mr. Cruz, this is the time for your initial appearance. You're here for a couple of different matters this morning. There's a warrant that issued out of Pima County Justice Court on a charge of criminal damage alleged to have occurred in January of 2022, and the warrant was issued in August of 2022. And then you have another warrant out of Pima County Justice Court that is for It looks like a domestic violence contempt of court misdemeanor charge from June of 2015, and
What?
the warrant was issued on October 30th of 2023. And then you have new felony charges of criminal damage and possession of drug paraphernalia. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney in the felony matter, and I am appointing the public defender's office to represent you. And we are going to discuss your conditions of release. I have reviewed the interim complaint for the felony charge. I have also reviewed information from pretrial services, which lets me know whether you have any prior felony history. It also lets me know what information you were able to provide regarding your ties to the community and any references. And then it contains their assessments and recommendations. And I have also reviewed the county attorney's office recommendation. They are asking that you be held on a bond of $1,000. Would the state like to be heard further? And defense.
Yes, Your Honor. So it appears Mr. Cruz may have been incarcerated in and around 2015. So we're not sure the circumstances with that. I'm sure that that's something he can look into. As it relates to the felony criminal matter, I'd ask that you release Mr. Cruz to pretrial services supervision. It appears that his sister in Marana has a home available to him, transportation available to him to get him to and from his court dates. I think given Mr. Cruz's financial circumstances here, $1,000 bond is beyond what he's, has the capability of posting. And so I think pretrial services release is going to be sufficient here, especially given the fact that he hasn't had any failures to appear in the last 2 years. And the charges here are, class 6 level offenses based on what the state has alleged. I imagine that there's going to be more to this story once there's further investigation on the defense's part. It's just easier to do that with access to our clients if they are released back into the community, especially when there's family members who are willing to take them and help them out and make sure that they show up for their court date. So for those reasons, Your Honor, I think pretrial services is going to be the ticket here to make sure that Mr. Cruz is able to participate in his case and keep the community safe. Thank you.
Thank you. I will order, Mr. Cruz, that you be released to pretrial services. You'll be required to submit to monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victims of the criminal damage, and do not return to that incident location. Your next court date will be scheduled as a preliminary hearing on October 27th at 1:30, and if you fail to appear, a warrant can issue for your arrest. Then we will turn to the misdemeanors. So on the one from 2015, I will also give you a chance to own. Your court date will be October 7th. What time is that at? October 7th for Pima County Justice Court.
That's today, Your Honor.
Oh, sorry. It's a case management. Is it today at noon? That's what it says in here. Okay. Let me look at the other one. Or should it be the 17th? Okay. All right. So it should be the 17th. There was just a typo in here. All right. So it'll be October 17th at 8:30 for a case management conference. No alcohol or illegal drugs, no acts of domestic violence. And then for the I put that in the wrong one. Okay. No, it is the right one. Okay. For the other charge out of Pima County Justice Court, your next hearing will be an arraignment on October 17th at 10:30 in the morning. No alcohol or illegal drugs, no contact with the alleged victim, do not return to the incident location, no acts of domestic violence, and that will be, like I said, October 17th at 10:30, and if you fail to appear, a warrant can issue for your arrest. Do you understand, Mr. Cruz?
Yeah.
All right, thank you. That's all for today.
Perdóname. Cruz. Cruz. Dale.
All right, please state your name.
Alexander Dorame.
Mr. Dorame, this is the time for your initial appearance. You are here on felony charges of misconduct involving weapons, escape in the second degree, and possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the legal defender's office to represent you. And we are going to discuss your conditions of release today.
Hey.
1 second here. I have reviewed the interim complaint that describes the circumstances surrounding your arrest. I have also reviewed pretrial services information about you that lets me know whether you have prior criminal history, and if so, what that looks like. It also lets me know what information, if any, you were able to provide, or any references regarding your ties to the community. And it also contains their assessments and recommendations. And then the Pima County Attorney has submitted a recommendation that you be held on a bond of $100,000. Would you like to be heard further, Mr. Poston?
Yes, Your Honor, one moment. Your Honor, this person allegedly threatened multiple persons with a firearm at a local QT over, apparently he didn't like how long somebody was using one of the air machines. He pointed a pistol at an innocent party. He's a multi-time felon with no restored gun rights. And police recovered the amount, one moment, recovered one moment. And the police recovered an AR-15, a Smith & Wesson 40, and again, the defendant threatened a AK vehicle, and he would, to quote, report, kill everyone. Your Honor, the community is only fortunate that this person's temper tantrum didn't turn into murder.
Thank you, Mr. Poston. From talking to the detective who reads the interims, it may have been that the allegation is that the defendant was the one using the air pump. Someone else complained that he was taking too long, and that's when the alleged behavior occurred. It is a little hard to tell from the interim itself. Defense.
Yes, Your Honor. I think it's important to note that no temper tantrum or attempted murder is charged here, nor is there even Miss charged here in this complaint by the arresting officers. What we're talking about is misconduct involving weapons to be prohibited possessor, escape in the second degree, and possession of drug paraphernalia, which looks like was scratched in, at the end of the complaint by perhaps a different officer. So, with this, Your Honor, I would ask that, if the court is going to impose a bond, that you take into account Mr. Dorami's financial circumstances. He's under no circumstances could afford a $100,000 bond. This is not charged as a violent offense. Mr. Dorame has no violent convictions for any offense of violence in his criminal history, according to what pretrial services has noted here. And they were able to get a hold of his mother, who is more than willing to take him and provide transportation to and from his court hearings. So as it relates to the charges that are actually alleged and the conduct described related to those charges, $100,000 bonds is not appropriate here. The court needs to take into consideration the circumstances surrounding the conduct that is actually charged as a crime, rather than what the state has described as uncharged conduct. Not the question of whether or not Mr. Dorame is going to be a threat to the community, to any illicit victim. And here there isn't one, because we're not talking about any crimes charged that have a victim alleged. The question before the court is whether or not this person seated next to me is going to be a flight risk. And I think the answer here is no, especially if the court is able and willing to impose a bond that Mr. Dorame would actually be in a position to afford and secure his release. So for these reasons, Your Honor, I'm asking that you impose a $5,000 bond, if you're going to impose a bond at all, such that Mr. Dorame would have the opportunity to post that bond, secure his release, and participate in his defense while being and remaining in the community as this case proceeds. Thank you.
Thank you. I am going to order that you're held on a bond of $10,000, cash or secured. If you're released, you'll be released to pretrial services, monitoring or treatment as directed by pretrial services. You may not possess or consume alcohol or illegal drugs. You may not possess firearms or weapons. You must surrender any firearms that are in your possession. Your next court date will be a preliminary hearing on October 17th at 1:30. If you fail to appear, a warrant can issue for your arrest. You understand, Mr. Dorme?
Yes, ma'am.
Thanks. That's all for today.
I got to see that.
Good morning. Please state your name.
Ms. Estrada, please, Ms. Estrada.
Thank you, Ms. Estrada. This is the time for your initial appearance. You're here this morning on charges of second-degree burglary. That is a felony offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. Also reviewed information provided by pretrial services that lets me know what felony criminal history you have. It also lets me know what information you were able to provide, if any, regarding your ties to the community or any references. And it also contains their assessments and recommendations. I have also reviewed the county attorney's recommendation. And the county attorney is asking that you be held on a bond of $7,500. And if released to pretrial services. Finally, I did note that you are on probation in another matter. There is no hold noted for me, but I don't know. Sometimes they come in after the calendar is created. So I just wanted to check with the jail and confirm that there are still no holds.
No hold at the time, Your Honor.
Thank you. Would the state like to be heard further regarding its recommendation?
No, Your Honor.
In defense.
Yes, Your Honor, I'm asking that you release Ms. Luz to the supervision of pretrial services. She does have a home available to her. She lives in Rita Ranch. She has transportation. She has a vehicle, so she's able to make court hearings. I want to note a couple things. The state's recommendation is apparently based on a history of violent or assaultive behavior, and that the defendant is a continued risk to the victim. I will note here, Your Honor, based on pretrial services, criminal history report attached, there's no crimes of violence, nor have they noted any sort of violent criminal prior history. So I don't believe that Ms. Luz is a violent person or has a history of assaultive behavior. That might have been a typo. Nor is there the incident here alleged to be a crime of violence or anything of that note. It appears to be some sort of dispute over the ownership of a trailer and in the trailer itself, which according to the claim, Ms. Luz had a key to. So I think that there's some, a substantial question here moving forward of whether or not this, even a crime was committed here at the level of burglary 2, which is what this is charged as, or if it's something that could, simply be described as criminal trespass or even no crime at all. And I'm sure that that information will be borne out further on as this case is investigated. But for the purpose of here and now, Your Honor, we're asking that Ms. Luz be released to pretrial services. She is currently breastfeeding. She very recently gave birth, so she's got a child to return to, a home to return to, and a vehicle to make sure that she's able to get to and from her court hearing. So for these reasons, Your Honor, I'm asking that you release her to pretrial services, you allow her to remain in the community and participate with the probation that is alleged here, which is, upon information belief, she's had no prior violations of. So for these reasons, Your Honor, I think pretrial services supervision is going to be appropriate in this case. Thanks.
Thank you. Ms. Estrada, I will order that you are released to pretrial services. You must submit to monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victim. Do not go to the incident location, and contact your assigned probation officer on the first working day following release from custody. Your next court date is set as a preliminary hearing on October 27th at 1:30. If you fail to appear, a warrant can issue for your arrest. You understand, Ms. Estrada?
Yes, ma'am.
That's all for today.
Mr. Bell.
Good morning. Please state your name.
Crystal Christine Ezel.
Ms. Ezel, this is the time for your initial appearance. You're here today on charges of possession of a narcotic drug. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release today, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services, which lets me know what criminal history you have, as well as what information you were able to provide regarding your ties to the community or any references. The state is recommending that you be released to pretrial services, and you may or the STEPS pre-indictment diversion program. That is a program that connects you with a substance abuse treatment provider, and if you successfully complete the requirements of the program, it's possible the state will not go forward with these felony drug charges against you. Are you interested in that program?
Yes, ma'am.
So I'm going to set your case for a hearing on October 14th. That's a week from today, at 9 a.m. to determine if you are in fact eligible for that program. If you, you'll also have the opportunity to learn more about it, so that if you are eligible, you decide if you're going to join. You only get one chance to appear for that. Then I am going to order that you're released to pretrial services. You'll be required to submit to monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. And I need to set a preliminary hearing for you. Usually that has to be set within 20 days. However, to give time for you to potentially join the diversion program, would you like to waive that out to 45 days?
Yes, Your Honor.
Thank you. I will set your preliminary hearing on November 21st at 1:30. If that hearing goes forward and you fail to appear, a warrant can issue for your arrest. Do you understand, Miss Izell?
Yes, ma'am.
Thanks. That's all for today.
Thank
Thank
you.
you, Judge.
Good morning. Please state your name. Mr. Gonzalez, this is the time for your initial appearance on a few different matters. You have new felony charges of possession of narcotic drugs and possession of drug paraphernalia. You have new felony charges of trafficking in stolen property. And you have misdemeanor charges of theft and criminal damage. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney in the felony matters, and it is ordered appointing the public defender's office to represent you. And we are going to discuss your conditions of release. I have reviewed the interim complaints describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services that lets me know whether you have any prior or pending felonies. It also lets me know what information you were able to provide regarding your ties to the community and any references. And it contains their assessments and recommendations. Finally, I have reviewed the state's requests. And so through the Pima County Attorney on the I believe it's on the drug charges. The state is recommending a bond of $2,500. And on the trafficking in stolen property, they are asking that you be held without bond. They are asking that pursuant to Article 2 of the Arizona Constitution, which states that if you are on release for a prior felony allegation, and you pick up a new felony allegation, you are not eligible for bail. And it does look like you were released to pretrial services in a separate felony case on September 7th. And let's see. The allegation here is that it looks like oh no, sorry, that's not right. It looks like the allegation of trafficking in stolen property is from September 8th. Is that correct, Mr. Poston?
It is, Your Honor.
And so for the case in which they are requesting that you be held without bond, I am going to order that you are held without bond, but I'm going to set a hearing on October 13th because there are additional elements that the state has to show. And so on October 13th, they will have the opportunity to either present their case or to recommend a bond on that date. And the court will decide what to do. And then I also need to set a preliminary hearing for you in that case. So I will set it for October 17th at 1:30. And if you fail to appear, a warrant can issue for your arrest. And then turning to the drug charges, would the state like to be heard further on the recommendation for a bond on the drug charges?
No, Judge.
Thank you. And defense?
Yes, Your Honor. Because this is steps eligible, I'm asking that you actually release Mr. Gonzalez to pretrial services so that if the no bond hearing doesn't move forward or the state elects to impose a bond and it's something that Mr. Gonzalez might actually be able to afford, that way he would be released on both matters and then would be able to begin the steps hearing and do what he needs to do in that matter. And so for these reasons, Your Honor, given that that's a substantial benefit to him, and I think, the circumstances here as the state's alleged, I think that's probably something that's going to help him, kind of fix the situation that he currently finds himself in and his living circumstances. So for those reasons, Your Honor, I think that pretrial services would be appropriate for the drug case. Obviously, he's going to be held on until the no bond hearing is resolved, and then his release conditions can be readdressed in the drug case if they need to be at that point. So at this point, Your Honor, that's why we're asking for pretrial services release.
Thank you. Since you are being held on the matter, I'm going to order a bond of $250 cash or secured on the drug charges. If you are released, you'll be released to pretrial services. Monitoring or treatment is directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victim. Do not return to the incident location. Sorry, that's for the other case, not for this one. So there's no victim in this one. And contact your pre-trial services officer on the first working day following release from custody. And then I will set your preliminary hearing on the same day and time as in the other case. That's October 17th at 1:30. And then on the misdemeanor charges, I will order that you are released on your promise to appear for court, and your court date is October 17th at 8:30. If you have been released before then and then fail to appear, a warrant can issue for your arrest. The additional conditions of your release are no contact with the alleged victim and do not return to the incident location. No alcohol or illegal drugs. Do you understand, sir? All right, thank you. That's all for today.
Mr. LaForest.
Somebody else.
Good morning. Please state your name.
Jean-Claude LaForest.
Mr. LaForest, this is the time for your initial appearance. You're here on charges of aggravated assault with a simulated weapon and felony criminal damage. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss the conditions of release today. I have reviewed the interim complaint describing the circumstances leading to the charges. I have also reviewed information provided by pretrial services, which lets me know whether you have any prior felony convictions or not. It also lets me know what information you were able to provide regarding your ties to the community or any references, and it contains their assessments and recommendations.
Thank you.
The county attorney also submitted a recommendation that you be held on a bond of $5,000 and if released to pretrial services. Would the state like to be heard further?
Nothing further.
Thank you, and defense.
Yes, Your Honor. I'm asking that you release Mr. LaForest to pretrial services supervision Just kind of as a preliminary note, he's got no prior criminal history, no history of violent offenses, doesn't appear to have misdemeanors or any failures to appear. So I don't think we're talking a situation in which Mr. LaForest is a flight risk. In terms of the charges in question, there's two that we're looking at here. One is simulated weapon, and it's described as a BB gun in the interim complaint. Generally, those are going to have orange tips. I understand that it's described as realistic looking. I don't know the specifics or the circumstances here, and I'm sure that photos of this item in question were taken, or the item itself was seized and will be revealed further on in the investigation with this case. That being said, Your Honor, I think it was clear to the officer as they described this item that it was a BB gun. And so if it was clear enough to the officer, I imagine it was clear enough to know that this wasn't a real weapon. And I think it's also worth noting that nobody here was injured. The alleged victim is Mr. LaForest's mother. And, she's described as, being in fear. Though, again, we're not a situation where anybody is described as being injured. The last thing I would note, Your Honor, is there's a criminal damage count charged as an F6. Actually, looking at 13-1602, unless there's a damage number, like a dollar amount associated, I think what we're actually looking at is 1602 B6, which describes in all other cases criminal damage as a class 2 misdemeanor. That's when there isn't a dollar number associated with the damage, or it's less than $250. On the complaint itself, it doesn't list a estimated damage number, so we don't know the value of the damage, if the computer was even damaged significantly at all, such that it requires repair or replacement. And so for those reasons, Your Honor, I'm asking that you find that there's no probable cause as to the criminal damage subsection that is actually charged here, because there's not a damage estimate included in the complaint. There's no probable cause to believe that the damage is what it has been charged at in this complaint. So taking that into account, and the circumstances here and the kind of mental health component that is already described in the complaint, I'm asking that you release Mr. LaForest to pretrial services supervision in light of his lack of a criminal history, lack of failures to appear, the circumstances here, and the issues with probable cause on that criminal damage count. Thank you.
Judge?
Yes. Do you have an argument on the probable cause for the criminal damage?
The state submits on the written record on the criminal damage. We do have a statement. The state does have a statement regarding the other issue.
Okay.
One, the fact that it's his mom makes it honestly an order of magnitude more egregious. And it is not a safe assumption to know that mom knew that it was not a real gun. We have nothing to say that there was the big orange knob on those things are easily removed. It just is what it is. Plus, I would say the operant question is the mindset of his mom, who said, and I quote from the report, moment. Hold on. Feeling, John pointed the BB gun at mom, her unaware of the firearm, feeling that she was in fear for her life. That is the operant fact, Your Honor. It's the mindset of the victim. So the state stands by its recommendation.
Thank you. So I don't think there was a probable cause argument on the ag assault. If there was, I do find probable cause for that. And I do not find probable cause for the criminal damage. I am going to order that you're released to pretrial services. You must submit to any monitoring or treatment as directed by pretrial services. You may not possess or consume any alcohol or illegal drugs. You may not possess any firearms or weapons, and you must surrender any firearms that are in your possession to local law enforcement while this case is pending, and you may not possess any simulated weapons while you are on release for this charge. Your next court date will be on October 27th at 1:30 for a preliminary hearing. If you fail to appear, a warrant can issue for your arrest. Do you understand, Mr. LaForest?
Yes.
And did I say no contact with the alleged victim and no, do not go to the incident location? I don't think I said those, but those are conditions of your release. If you were living there, you may return with a police escort to pick up your belongings. Pretrial services was not able to speak with the alleged victim in this case. We don't know her position on further contact or having you return to that home. However, only another court order can lift my no contact order. That's all for today.
Thank you, Judge.
Good morning. Please state your name.
Joshua Linville.
Mr. Linville, this is the time for your initial appearance. You are here this morning on charges of possession of dangerous drugs, possession of narcotic drugs, possession of drug paraphernalia, misconduct involving weapons, and destruction of evidence. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the legal defender's office to represent you. We are going to discuss your conditions of release, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information from pretrial services that lets me know whether you have any prior felony convictions, and if so, what those look like. It also lets me know what information you were able to provide regarding your ties to the community or any references, and it contains their assessments and their recommendations. And it lets me know that there is a probation hold currently. So you would not be released today, regardless of what I ordered in this case, until your probation hold was resolved. The state is recommending that I order that you be held on a $10,000 bond. Would the state like to be heard further?
No, Your Honor.
And defense.
Yes, Your Honor. Knowing that there's a probation hold, I'm going to ask that the court impose a nominal bond in this matter. There's a couple issues in terms of probable cause that I want to highlight for the court. One being the misconduct involving weapons, and the other, the destruction of evidence. So as it relates to the misconduct involving weapons, the interim complaint notes that the officer recovered a discarded item which they identified as a firearm. They don't say how or what kind of firearm or what it looked like or what caliber or the serial number or any of the things that we would use to identify that something is in fact a firearm, and not say a BB gun, a squirt gun, a model, a dummy, or anything of that note. Generally, and frankly, I'm a little surprised that it's described as such in the complaint, generally officers would know, the make and model of the firearm, or at least the serial number or something identifiable to show that it is in fact a firearm. They haven't done here today. I find that, frankly, strange, given the circumstances. And so just saying that it's a firearm, I don't think is enough to say that it truly is, because, there's nothing to show that is in fact the case, and it's not perhaps a simulated weapon or a airsoft gun or a paintball gun or something like that. And then as for the destruction of evidence, there's no description in the statement of probable cause for the destruction of evidence or what the officer claims the destruction of evidence was. It's not clear to me, given the circumstances alleged here, what the officer is referring to, and just putting it on the sheet and letting the court figure it out is not a statement of probable cause, which requires that the officer describe, the crime that they believe was committed and who committed it. And here we don't have that. So for these reasons, Your Honor, the lack of specificity on the misconduct involving weapons, I believe there's probable cause to dismiss that. And then there's probable cause to dismiss the destruction of evidence because there's not any description or detail or allegation as to what evidence was destroyed and how it was in fact destroyed. So for those reasons, Your Honor, I'm asking that you dismiss those counts on the basis of the lack of probable cause, and that you impose a nominal bond and hold Mr. Linville here on that nominal bond so that he does get the back time, but with the opportunity perhaps in the future to secure his release by bonding out. Thank you.
Thank you. I do find probable cause for all of the alleged offenses, and I am going to order a bond of $5,000 cash or secured. If you are released, you'll be released to pretrial services. Monitoring or treatment is directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. If you do own any firearms, you must surrender them to local law enforcement while this case is pending. And your next court date will be set as a preliminary hearing. That is on October 17th at 1:30. If you are released before then and fail to appear, a warrant can issue for your arrest. Do you understand, Mr. Linville?
Yes.
Thanks. That's all for today.
Thank you, Judge.
Lopez.
Good morning. Please state your name.
Xavier Lopez.
Mr. Lopez, this is the time for your initial appearance. You are here this morning on a couple of different matters. You have new felony charges of possession of drug paraphernalia, possession of a dangerous drug, and possession of a narcotic drug. And then you also have a number of cases out of Tucson City Court that were in warrant status. Those include, let's see, 3 separate counts of criminal trespass, 1 count of threats or intimidation, 1 count of criminal damage, and 3 counts of disorderly conduct. One of the disorderly conducts, the threats and intimidation, and the criminal damage are all domestic violence offenses. You have the right to remain silent on all of these charges. Anything you say can and will be used against you. You have the right to be represented by an attorney in the felony matter, and I will appoint the legal defender's office to represent you. Under some circumstances, you may qualify for court-appointed counsel in the misdemeanor charges. And we are going to discuss your conditions of release today. I'm going to start with the misdemeanor matters. So for your cases out of Tucson City Court, I am going to order that you are held on a bond of $500, cash or secured. You may not possess or consume any alcohol or illegal drugs. You may not commit any acts of domestic violence. No contact with the alleged victims of the criminal trespass, threats or intimidation, criminal damage, and disorderly conduct charges. Do not return to those incident locations. Abide by any previously ordered conditions of release, and I will appoint the City of Tucson Public Defender to represent you. If you remain in custody, your next court date will be a video review hearing on October 17th at 1:45. If you have posted your bond and been released before then, Tucson City Court will actually vacate that date, and instead your court date will be November 12th at 2 p.m. And if you fail to appear, a warrant can issue for your arrest. Do you understand, Mr. Lopez?
Yes.
Thank you. And then on the felony matter, I have reviewed information provided by pretrial services. That lets me know whether you have any prior criminal history. It also lets me know what information you were able to provide regarding your ties to the community or any references. And it also contains their assessments and recommendations. I have reviewed the state's recommendation, which is that on the felony matter, you be released to pretrial services. And that it also says that you may be eligible for the STEPS pre-indictment diversion program for the felony matter. That is a program that connects you with a substance abuse treatment provider. And if you successfully complete the requirements of the diversion program, it is possible that the state will not go forward with the felony charges against you. Are you interested in that program, sir?
Yes, ma'am. And so let's see. So that the job Tennessee 17th of this month from my son. Just all that things that I didn't have a job. It's just today. But that
Great. So I am going to set a hearing on October 14th at 9 a.m. That is to determine if you are eligible for the diversion program, and if so, for you to learn more about it and decide whether you would like to join it. You only get one chance to appear for that program, so it's very important to show up to that hearing. And then the state was recommending that you be released to pretrial services. Given the misdemeanor hold, I don't know if you would like to be released to pretrial services or if you would like a small bond to ensure time credit.
I would like to be used to reach out services because I've done it before, ma'am. And like I said, I was telling the attorney here, I have a housing voucher that I was just given by the city of Tucson, and I'm not trying to blow that off, because it's a once in a lifetime opportunity. And I've been in contact with my caseworker and stuff like that. I got a dependency hearing on the 17th of next month, and I'm not trying to show that over here.
Okay. Anything further from counsel?
No, Your Honor. So if, at a later date, I'm sure that the time credits can be adjusted and show the credit that he's had. But I think given the steps, I think release to pretrial services makes sense here. I'm sure that the city public defender will likely see it the same way. And as I was just explaining to him, we'll have the opportunity to address the bond in the city case and potentially get him out and get him connected with steps.
All right, great. So I will order that you are released to pretrial services, monitoring your treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons, and your next court date will be a preliminary hearing on October 27th. I don't know do you want to waive it out further or no?
My concern here is that he's going to be held and might miss the steps hearing because he's in custody. So
Okay.
I don't know that we want to waive the peach. I don't know if it'd be possible, Your Honor, to set a later time, because conceivably he could be released on the 14th and would be pretty hard pressed to get to the steps hearing. And since he's got one shot at it, my request is rather than not waive the PH, we'd be willing to waive the PH and set it out 45 days if the court is in a position to schedule a later steps hearing.
Okay. I think I can do that. So you want me to set it for the day after his hearing in city court?
I think that would be fine.
Okay, so that will be Monday the 20th for the steps hearing at 9 a.m. And then the preliminary hearing will be October 27th at 1:30.
Excellent. Thank you, Judge. And thank you for understanding.
And you understand, sir, that if you fail to appear for the preliminary hearing and you've been released from your misdemeanor cases, that a warrant can issue for your arrest?
Yeah.
All right, thank you. That's all for today. Good morning. Please state your name.
Jose Nava Lozano.
Mr. Lozano, this is the time for your initial appearance. You're here this morning on one felony count of aggravated assault, domestic violence, and then you have 3 misdemeanor charges, assault, disorderly conduct, and another disorderly conduct, which are all domestic violence offenses. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release today. I have reviewed the information provided by pretrial services. That lets me know whether you have any prior felony history. It also lets me know what information you were able to provide regarding your ties to the community or any references or any relevant misdemeanor charges. And it also contains their assessments and recommendations. Finally, I have reviewed the Pima County Attorney's recommendation that you be held on a bond of $35,000 and if released to pretrial services. Would the state like to be heard further?
No, Your Honor. This actually one. Your Honor, yes, Your Honor, given the egregious nature of the 13-year-old victim, the state is very concerned. This person has priors, substantial misdemeanors, and the state wouldn't be a bit surprised if this is going to be a prison-only plea offer. All things considered, $35,000 is appropriate.
Thank you. And defense.
Yes, Your Honor. I'm asking that you release Mr. Lozano to pretrial services, or at the very least, impose a bond if the court is inclined to do so, something that he might be able to afford. He does actually have housing available to him. His sister, upon information and belief, has recently moved from Tucson. She still owns a home here in town that Mr. Lozano could stay at, so that he's living separate and apart from the folks listed as victims in this case by the state. I will note, Your Honor, that the most serious charge here is an F6. Mr. Lozano's prior criminal history, according to pretrial services, are nonviolent convictions. He doesn't have any convictions for any crimes of violence, evidently at either the misdemeanor or the felony level, nor does he have any failures to appear in the last couple of years. So I think that, the court's concern here is obviously going to be the safety of the alleged victims, and then whether or not Mr. Lozano can be relied upon to show up to his hearings. I think the answer to both of those is yes, that the alleged victims would be kept safe if he's living separate their security would be ensured by that. And he, because he's working and has a place to go to here in town, is not a flight risk either. So as for the prior felony criminal history, by my review, the most recent one is over a decade old. And we're not talking, again, domestic violence or crimes of violence for these prior felony convictions, as noted by pretrial services. So in terms of, what's an appropriate release condition, I think the supervision of pretrial is going to be sufficient, or at the very least, imposition of a bond that Mr. Lozano would be able to afford. He's in therapy. He is, starting what he needs to do and would like to maintain doing what he needs to do to avoid allegations and incidents such as this in the future. We're just asking that you give him the opportunity to do that with the supervision of pretrial. Thank you, Judge.
Thank you. Mr. Lozano, I am going to order that you're held on a bond of $7,500. That will be cash or secured. If you're released, you'll be released to pretrial services, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons, no contact with the alleged victims, do not go to their residence or workplace. You may return one time with a police escort to obtain your necessary belongings. You must establish an alternate address and no unsupervised contact with minors. Your next court date is scheduled for a preliminary hearing. That's going to be on October 17th at 1:30. And if you fail to appear, a warrant can issue for your arrest. Do you understand, Mr. Lozano?
Yes, Your Honor.
Thanks. That's all for today.
Ms. Madrid? Madrid? Over here, over here, over here.
Good morning. Please state your name. I'm sorry. I don't know why, but I couldn't hear you.
Yes, Miss Madrid.
Thank you. Ms. Madrid, this is the time for your initial appearance. You're here on a couple of different matters. You have new felony charges of possession of a dangerous drug and possession of drug paraphernalia. And then you also have misdemeanor charges out of Tucson City Court for criminal trespass, obstruction, and unlawful possession of a prescription drug. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. We are going to discuss your conditions of release today. And I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services, which lets me know whether you have any prior felony convictions. It also lets me know what information you were able to provide regarding your ties to the community or any references and their assessments and recommendations. And then it looks like you may be eligible on the new drug charges for the pre-indictment diversion program known as STEPS, which is a program that connects you with a substance abuse treatment provider. And if you successfully complete the requirements of that program, it is possible that that the state may not go forward with the felony charges. And it also shows that you have a parole violation warrant, so you have a hold from DOC on your account, so you would not be released today regardless of what I ordered in this case until your DOC hold was resolved. Given all of that, and the state is recommending that you be held on a bond of $1,000 and if released to pretrial services. Would you like to be heard further, Mr. Poston?
No, Your Honor.
And defense.
Your Honor, I'm going to ask the court for just a nominal bond on this steps matter. I think that it would be to Ms. Madrid's benefit to enroll in steps. Obviously, she can't. And it looks as if the parole hold is going to be at least a few months. And so, be that as it may, I'd ask for just a nominal bond here such that when the parole issue is cleared up, she might be able to have her release conditions addressed in the future, or perhaps bond out and see about getting enrolled in steps.
So you would like me to set the steps hearing on October 14th?
Yes, Your Honor. So she gets the contract. It might be that they are able to continue that out to a time which she might be able to actually participate. Obviously, if she's held in custody, then she's not going to be, she's not missing it on her own involuntary, or failure to be there because she's in custody. So I would ask for a bond, and I would ask that you set this hearing, make sure she gets time credits, but she gets that step contract as well.
So I will order setting the steps hearing on October 14th at 9 a.m. At that hearing, you will find out if you are eligible for the program, and if so, if you would like to join after you learn more about it. I will order a bond of $250 cash for secured pretrial services if the bond is posted, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. And I'll set your preliminary hearing on October 17th at 1:30. If you have been released before then and you fail to appear, a warrant can issue for your arrest. And then in the Tucson City Court matter, I am going to order that you are released on your promise to appear for future court dates. No alcohol or illegal drugs, no contact with the alleged victim of the criminal trespass. Do not go to the incident location. I will appoint the City of Tucson Public Defender to represent you in that matter. And your next court date will be either a pretrial conference or non-transport review on December 12th at 9 a.m. If you are out of custody and fail to appear, a warrant can issue for your arrest. Do you understand, ma'am? Ms. Madrid, do you understand that if you fail to appear for court, a warrant can issue for your arrest?
I say yes.
All right, thank you. That's all for today. Please state your name.
Brenda Nario?
Ms. Nario, this is the time for your initial appearance. You're here this morning on charges of misconduct involving weapons and possession of drug paraphernalia. Those are felony charges. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release today. I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services, which lets me know whether you have any prior felony convictions and also what information you were able to provide regarding your ties to the community and any references. And it also lets me know their assessments and recommendations. Finally, I have reviewed the state's recommendation that you be held on a bond of $5,000. And if posted, released to pretrial services. Would the state like to be heard further?
No, Judge.
Thank you, and defense.
Yes, Your Honor. I'm asking that you release Ms. Nario to the supervision of pretrial services. Of note here is that Ms. Nario does not actually have a history of violence or assault of behavior. To the supervision of pretrial services. Of note here is that Ms. Nario does not actually have a history of violence or assaultive behaviors included in the state's recommendations, doesn't note any violent convictions. The one prior felony conviction that pretrial services notes is for drug possession. This itself, as the state has alleged, is not a crime of violence, nor is Ms. Nario charged with anything that could be described as such, or even as a crime involving a victim. So what she's charged with is being a prohibited possessor and then possession of drug paraphernalia, neither of which I think, presents a specific directed danger to the community. And again, there aren't any alleged victims in this matter. Ms. Nario does actually have a verified address. She lives with her mother and sister, as confirmed by pretrial services, as well as her children at an address off of Drexel. Her sister confirmed that she would be able to return back home, that they do have transport for her, and that she is welcome to, in fact, return home and participate in her defense from being released to the community. So I think pretrial services supervision here, Your Honor, is going to be more than sufficient to ensure Ms. Nario's compliance, participation, appearance in court hearings, and the safety of the community as well. Thank you.
Ms. Nario, I am going to give you an opportunity on pretrial services release. You will be required to submit to monitoring or treatment as directed by pretrial services. You may not possess alcohol or illegal drugs. You may not possess firearms or weapons, and you must surrender any firearms that are in your possession to local law enforcement. I'm also going to order that you cannot have any contact with your co-defendant, Mr. Durame. And your next court date will be scheduled as a preliminary hearing because I am going to set that on the same date as the co-defendant's preliminary hearing, so that will be October 17th at 1:30. If you fail to appear for that hearing, a warrant can issue for your arrest. Do you understand, Ms. Nario?
Yes, I do, ma'am.
Thank you.
Thank you.
Thank you, Judge.
Mr. Salazar. Your Honor, Dale here. Just wanted the court to be aware that Mr. Salazar does have a DOC hold map.
Oh, thank you. All right, please state your. Oh, sorry. You can have a moment if you want it.
One second, Your Honor. All righty, Judge. I think we're ready.
All right, please state your name, sir.
Randy James Salazar.
Mr. Salazar, this is the time for your initial appearance. You're here this morning on charges of aggravated assault, which is a domestic violence offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release today. I have reviewed the interim complaint describing the circumstances surrounding your charges. I have also reviewed information provided by pretrial services that lets me know whether you have any prior felony convictions or relevant misdemeanors. It also lets me know what information you were able to provide regarding your ties to the community and any references. And it also contains their assessments and recommendations. Finally, I have reviewed the Pima County Attorney's request or recommendation that you be held on a bond of $35,000 and if released to pretrial services. Would the state like to be heard further?
Your Honor, yes, he's got, on several occasions, we've got a failure to appear, so he is a flight risk. 2017, devious assault, fled down to DV unlawful in prison. He's got a DV history. He's got a violent history, Your Honor. DV on several occasions, misto and felony. He's got to hit this. This person has a lot of DV in their past convictions. 35,000.
Thank you. And defense.
Yes, Your Honor. Because there's a DOC hold that isn't going to expire for several months, according to pretrial services, I'm asking that you impose a nominal bond in this case, just so that Mr. Salazar is able to get his back time. It seems as though he will be in custody, held on that DOC hold, at least through January of 2026. So for these reasons, Your Honor, I don't believe that a substantial monetary bond of tens of thousands of dollars is going to be appropriate here, given the fact that Mr. Salazar is going to remain in custody. And the amount requested by the state, I understand, the allegations and the history involved. But the fact of the matter is Mr. Salazar is of limited financial circumstances. And that's something that the court would have to take into account in imposing a monetary bond. It's got to be something he has the potential to actually afford and secure his release. And so for these reasons, Your Honor, I'm asking that you impose a bond so he gets his time credit, but do so at a level that Mr. Salazar might at some point have the opportunity to post and secure that release. Thank you.
Thank you. I do see a number of historical lower bonds and continued allegations of domestic violence. I am going to order the bond of $35,000 cash or secured. If you are able to post that bond and aren't being held on another matter, you will be released to pretrial services, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons. If you do own any firearms, you must surrender them to local law enforcement, no contact with the alleged victim, that starts immediately, and do not return to the incident location, establish an alternate address. If you were living with the victim, you can return one time with a police escort to obtain your necessary belongings. You'll take my order to the nearest police station and they will escort you to the residence to obtain your belongings. Your next court date is scheduled as a preliminary hearing. That's on October 17th at 1:30. And if you fail to appear, a warrant can issue for your arrest. Do you understand, Mr. Salazar?
Yes, Your Honor.
Thank you. That's all for today.
Thank you, Your Honor.
Please state your name.
Dominic Simpson.
Mr. Simpson, this is the time for your initial appearance. You're here today on charges of possession of narcotic drugs, possession of dangerous drugs, and possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release today. I have reviewed the interim complaint as well as information from pretrial services regarding whether you have a criminal history, what information you were able to provide regarding your ties to the community, or any references, as well as their assessments and recommendations. The county attorney's office is recommending that you be released to pretrial services, so I will order that you are released to pretrial services. It looks like you may also be eligible for a pre-indictment diversion program known as STEPS. That program connects you with a substance abuse treatment provider, and if you successfully complete the requirements of the program, it is possible that the state will not go forward with these felony drug charges against you. Are you interested in that program, Mr. Simpson?
Yes.
All right, so I will set a hearing on October 14th at 9 a.m. to determine if you are in fact eligible for that program and if you would like to join it after you get the opportunity to learn more about it. You only get one chance to appear for that. I will order that you are released to pretrial services. You must submit to any monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. And I do need to set a preliminary hearing for you. Usually that has to occur within 20 days. However, to give time to potentially join the diversion program, would you like to waive that out to 45 days? Mr. Salazar.
Do you want to do this, Judge?
I was going to get out.
Yeah, so that's it. So we can do it. So
Yeah, he'd be willing to waive the preliminary hearing, Judge.
Okay.
Or push it out to 45 days.
So I will set your preliminary hearing for November 21st at 1:30. If you have joined the STEPS program, it's possible that hearing will not go forward. However, if that hearing does go forward and you fail to appear, a warrant can issue for your arrest. You understand, Mr. Simpson?
Yes, ma'am.
Thanks. That's all for today.
Mm. Thank you, Judge. Ms. Ward? It's, uh,
Please state your name.
Amy Elizabeth Ward.
Ms. Ward, this is the time for your initial appearance. It looks like you were arrested on a warrant out of Gila County for charges related to drugs and possessing a weapon during a drug offense. Let's see. And possession of drug paraphernalia and theft. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney in Gila County. And we are going to discuss your conditions of release today. There's an administrative order that directs me to give primary consideration to the bond set by an out-of-county judge, and reviewing the limited information that is available to me. A $1,000 bond does appear reasonable in this circumstance, so I will affirm the $1,000 bond that was issued by the Gila County judge. I will also set a review hearing for about 30 days from now, just to make sure we don't lose track of this out-of-county warrant. If you have been released either on bond or to Gila County, you do not need to worry about our review hearing. If you are still being held here in the Pima County Jail for some reason, then the Pima County Jail will make you available. Do you understand?
Yes.
All right. That hearing is November 7th at 9 a.m. And that's all for today. Thank you, Ms. Ward.
Oh, yeah.
Please state your name.
Daniel Waterbury.
Mr. Waterbury, this is the time for your initial appearance. You're here this morning on charges of unlawful possession of a narcotic drug, unlawful possession of drug paraphernalia, and possession of a dangerous drug for sale. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. We are going to discuss your conditions of release today, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. I've also reviewed information provided by pretrial services that lets me know whether you have any criminal history or not. It also lets me know what information you were able to provide regarding your ties to the community or any references. And it contains their assessments and recommendations. The county attorney is asking that I hold you on a bond of $15,000. And if you post that bond, that you be released to pretrial services. Would the state like to be heard further?
No, Judge.
Thank you. And defense.
Your Honor, I'm asking that you release Mr. Waterbury here to the supervision of pretrial services. He's got no felony criminal history. According to pretrial services, no failures to appear at all registered. So I understand, he's kind of in a tough spot with his living situation currently. But the fact of the matter is, there's not a crime of violence alleged here, so there's not any alleged victims that the court need be concerned with. It's, I think kind of clear from the circumstances here, Mr. Waterbury has been living in Tucson and obviously had access to a vehicle. Because of the circumstances of his arrest, that might, no longer be the case. However, I'm asking the court to give him the opportunity to, attend his court hearings, participate in his defense, and do so while remaining in the community under the supervision of pretrial services. I don't believe, given the circumstances and the allegations here, that Mr. Waterbury is a flight risk. We're not talking about a threat to any alleged victim because there are none listed. And in terms of the threat to the community that the court need be concerned with here, the allegations that the state has brought is a fairly low quantity of drugs for what they are claiming to be possession for sale. In my experience, often when we're talking about quantities of this or even, greater amounts than this, oftentimes what happens is when it gets presented to the grand jury, it ends up being personal possession rather than possession for sale. And so I suspect that this might be one of those cases, just because of the circumstances alleged here. The complaint lists that this vehicle was at a park, but was also apparently not leaving an address in an alleyway. So, it's difficult to say exactly what, is being alleged here when, the contact with a homeless population when Mr. Waterbury himself is homeless. So that isn't suspicious in and of itself. The quantities alleged, though higher than I suppose would be immediately apparent to an officer as personal possession, very frequently, Your Honor, end up being personal possession once cases like these move forward. So given these circumstances, Your Honor, I'm asking you to give Mr. Waterbury a chance on the supervision of pretrial services and allow himself to participate in his defense while being released back to the community. Thank you.
Judge,
Yes.
state would respectfully disagree with defense. What we see here, first off, as far as risk, the case load is awash with people overdosing from one hot dose of M30s. Plus, we have, in this case, search incident to arrest was almost 11 grams of NIC tested positive methamphetamine, 311 in cash, which may fit under counsel's description as personal use until we get to the fact that we have bags, a scale, foil with burnt residue, and a substance packaged separately. Those are all indicias of sale, Your Honor, and considering we never know if there's going to be a hot dose that'll kill somebody, there is a risk to the community, and this is a sales case, Your Honor. Thank you.
Thank you. Mr. Waterbury, I am going to order that you're held on a bond of $2,500. That will be cash or secured. If you are released, you'll be released to pretrial services. Monitoring or treatment is directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. And I will set your preliminary hearing for October 17th at 1:30. If you are released and fail to appear, a warrant can issue for your arrest. Do you understand, sir?
Yes, Your Honor.
Thank you. That's all for today. And thank you to the Pima County Jail. I believe we're moving.
We're here, Judge.
Thank you. Sir, please state your name.
Eduardo Antonio Garnica.
Mr. Garnica, This is the time for your initial appearance. You are here today on a misdemeanor charge of interfering with judicial proceedings, which is a domestic violence offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and under certain circumstances, an attorney may be appointed on your behalf. We are going to discuss your conditions of release today. I have reviewed the booking information and information from pretrial services. That lets me know what information they were able to obtain from speaking with the alleged victim. And it also lets me know what information you were able to provide regarding your ties to the community or any references. And it contains their assessments and recommendations. Mr. Garnica, if I ordered that you were released on your promise to appear for future court dates, would you appear for your future court dates?
Yes, most definitely. I work, so like I do concrete out there in Buckeye, Surprise, Phoenix areas, and like I was supposed to be at work today at 3 in the morning, and I have my own small business also, so like I will have to be at court, like I can't throw none of that away.
All right. Well, let me tell you, Mr. Garnica, that if you don't show up to your court date, likely the judge will issue a warrant for your arrest, and you're going to end up missing work in a much less convenient time than if you plan for it in advance. So your court date is going to be scheduled for November 18th at 9 a.m. That's in Ajo Justice Court. And if you fail to appear, a warrant can issue for your arrest. So please do make arrangements to appear for that court date. You may not possess or consume any alcohol or illegal drugs. You may not commit any acts of domestic violence. I am not going to make any particular orders about your contact with the victim today. However, based on what the charge is, I'm assuming another court has made an order. And so if there is a court order saying that you cannot have contact with the alleged victim, that court order is still standing, and having contact with the alleged victim would be a violation of that court order. Do you understand that, Mr. Garnica?
Yeah.
Okay.
Yes.
All right. So your next court date is November 18th. Your conditions of release are no alcohol or illegal drugs and no acts of domestic violence. And that's all for today.
Yes, we heard. Thank you.
Thank you.